Thank you. Please be seated, everyone. Let me inquire, Mr. Burkhardt, is the system working well for you?
Yes, it is.
Excellent, excellent. Folks, thank you very much for getting here this morning. I need to ask you whether or not any member of the jury panel was exposed to any information between 4 o'clock yesterday when I last saw you and this moment, whether you engaged in conversations with others, with each other, or sought intentionally or were unintentionally exposed to any information about the case. If so, raise your hand. Mr. Burkhardt.
Yeah, I got a soup and a Campbell soup. Governor Campbell on the list. I like Campbell soup.
It is possibly a name that I read yesterday. There were a lot that I don't remember, but other than that, we're good. All right, good. Thank you. Thank you. I didn't see any other hands. The first thing we do this morning, folks, is provide you with preliminary jury instructions. We have, frankly, instructions for almost everything to help explain the law to the jury and to give guidance. And that's the intent of these. They first start out giving you some firm, concrete reinforcement of what I've already told you about what you need to do in this process and how this process will proceed. There are then standard instructions about evidence and about your role and what you should and should not expect as far as evidence in this case. And then a substantive instruction on each of the counts, describing to you the elements that the state has to prove beyond a reasonable doubt and how to interpret some of those terms, including, finally, the meaning of reasonable doubt, the presumption of innocence, etc. Now, for purposes of this preliminary instruction, I did combine the counts in the information so that I'm not reading all 8, but I'm reading 4 with a reference in each to the count regarding Bart Halderson and the count regarding Krista Halderson, simply to save time and because you're not reaching determinations today. You don't reach any determinations until we send you to the jury room for that purpose. But just to save time, because the elements are the same, whether it's the first count or the 5th count. Before the trial begins, there are certain instructions you should have to better understand your functions as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based only on the evidence presented at trial and the law given to you by the court. Anything you may see or hear outside the courtroom is not evidence. Do not let any personal feeling about race, religion, national origin, sex, or age affect your consideration of the evidence. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the lawyers. If you come into contact with the parties, lawyers, or witnesses, do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene. Do not read any newspaper reports or listen to any news reports on radio or television or electronic devices about this trial. Do not consult dictionaries, computers, websites, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about this case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer about this case until after you are discharged from your duties. Do not permit anyone to communicate with you, and if anyone does so, despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and discussion and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to ensure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide this case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. And third, any fact to which the lawyers have agreed or stipulated, or which the court has directed you to find. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. You are not required to, but you may take notes during this trial, except during opening statements and closing arguments. The court will provide you with materials. In taking notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during deliberations. You should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and testimony introduced during the trial. During the course of a trial, the attorneys may refer to or use police reports with witnesses. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to police reports. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Count 1 and Count 5 of the amended information each allege that the above-named defendant, Chandler M. Halderson, on and or between July 1, 2021 and July 8, 2021 in Dane County, Wisconsin, did, as to Count 1, cause the death of Bart A. Halderson with intent to kill that person, and as to Count 5, cause the death of Krista R. Halderson with intent to kill that person, both contrary to WISSTAT Section 940.01, Sum 1, Sub A. To these two charges, Chandler M. Halderson has entered a plea of not guilty, which means the state must prove every element of each offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of either of these offenses, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present for each count. Number one, the defendant caused the death of Bart A. Halderson and, as to the second charge, caused the death of Krista R. Halderson. Cause means that the defendant's act was a substantial factor in producing the death. Element 2, the defendant acted with the intent to kill Bart A. Halderson and, as to the second charge, acted with intent to kill Krista R. Halderson. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant, as to the first count, caused the death of Bart A. Halderson and, as to the second count, the fifth count, caused the death of Krista R. Halderson with, as to each count, the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Count 2 and Count 6 of the information each allege that the above-named defendant, Chandler M. Halderson, on and or between July 1, 2021 and July 8, 2021 in Dane County, Wisconsin, did deliver written and or oral communication with intent to induce a false belief that the defendant had knowledge of the whereabouts or physical condition of a missing person, Bart A. Halderson as to Count 2, and Krista R. Halderson as to Count 6, both contrary to WISSTAT Section 946.48, Sub 1. To these two charges, Chandler M. Halderson has entered a plea of not guilty, which means the state must prove every element of each offense beyond a reasonable doubt. Section 946.48 of the Criminal Code of Wisconsin is violated by one who sends, delivers, and or causes to be transmitted to another any written or oral communication with intent to induce a false belief that the sender has knowledge of the whereabouts of a missing person. Before you may find the defendant guilty of either of these offenses, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present for each count. Number one, the defendant sent, delivered, or caused to be transmitted a written or oral communication to Dane County Sheriff's deputies. Element two, the defendant did so with the intent to induce a false belief that he had knowledge of the whereabouts of a missing person, specifically Bart A. Halderson as to count 2 and Krista R. Halderson as to count 6. This means that the defendant had the mental purpose to cause the Dane County Sheriff deputies to believe that he had knowledge of the whereabouts of a missing person, specifically Bart A. Halderson and Krista R. Halderson, or was aware that his conduct was practically certain to cause Dane County Sheriff deputies to believe that he had knowledge of the whereabouts of a missing person. Again, specifically Bart A. Halderson and Krista R. Halderson. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that the two elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 3 and count 7 of the information each allege that the above-named defendant, Chandler M. Halderson, on and or between July 1, 2021 and July 8, 2021 in Dane County, Wisconsin, did, as to count 3, dismember the corpse of Bart A. Halderson with the intent to conceal a crime, and as to count 7, dismember the corpse of Krista R. Halderson with the intent to conceal a crime, both contrary to Wistat Section 940.11, Sub 1. To these two charges, Chandler M. Halderson has entered a plea of not guilty, which means the state must prove every element of each offense charged beyond a reasonable doubt. Section 940.11, Sub 1 of the Criminal Code of Wisconsin is violated by one who mutilates, disfigures, or dismembers a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of each of these offenses, or either of these offenses, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present for each count. Element 1, the defendant dismembered a corpse. Element 2, the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Count 4 and count 8 of the information each allege that the above-named defendant, Chandler M. Halderson, on and or between July 1, 2021 and July 8, 2021 in Dane County, Wisconsin, did, as to count 1, hide the corpse of Bart A. Halderson with the intent to conceal a crime, and as to count 8, hide the corpse of Krista R. Halderson with the intent to conceal a crime, both contrary to Wistat Section 940.11, Sub 1. To these two charges, Chandler M. Halderson has entered a plea of not guilty, which means the state must prove every element of each offense charged beyond a reasonable doubt. Section 940.11, Sub 2 of the Criminal Code of Wisconsin is violated by one who hides or buries a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of either of these offenses, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present for each count. Element 1, the defendant hid a corpse. Element 2, the defendant hid a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of these offenses have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdicts, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless, in your deliberations, you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause which would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to decide whether the state has overcome the presumption of the defendant's innocence and proven the defendant guilty beyond a reasonable doubt. The lawyers will now make opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show, so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. Attorney Brown.
Thank you. Could I have the screen turned?